Again, thank you all so much for coming. We'd like to acknowledge and welcome Assembly Member Blanca Pacheco, who will be joining us likely via teleconference. We're very excited to have her expertise and her input as part of a commission member. So welcome, Assembly Member Pacheco. We also, in our audience here, have Professor Diane Boyer-Vine, who is a longtime civil servant and has been on this commission before. She has been incredibly valuable to California. Folks don't even know how much this woman has done for California. So it's a pleasure to have her here, as well as Stephen Bonaris from UC Law SF. Professor Bonaris, you are in great company, so that says something about you there. We also want to recognize Cesar Chavez Day. I know that some federal administration has not recognized that day, but here in California, we value the work of Cesar Chavez and Dolores Huerta, and the UFW here have supported our workers and our businesses throughout California. So we want to make sure to acknowledge the great achievements that they have moved forward here. So thank you all so much. We'll now proceed to agenda item 1, which is the minutes of January 23, 2025. It is memorandum 2025 12. All of our agendas are online, as well as all of the memos and material are online for everyone to have access to.
I'll move approval.
Do I hear a second?
Ask if there's any public comment?
I
Did
think-
already. Okay. Okay.
Is there any conversation or comments regarding the first and second from the commissioners? Having none, can we please call public comment? Great. Can we please call roll?
Of course. So hopefully everybody can hear me. I'm going to call the roll on the minutes. Commissioner B.
Aye.
Senator Blake Spear is not present. Commissioner Carrillo.
Aye.
Commissioner Carrion.
Aye.
Commissioner Kubas.
Aye.
Commissioner Hebner.
Aye.
Commissioner Jenkins.
Aye.
Commissioner King. And Commissioner Simpson.
Aye.
Wonderful. Motion passes. Now moving on to agenda item 2, administrative matters. First being our report for our executive from our.
Thank you. Last time we introduced 3 of our UC Law San Francisco externs. Since the last meeting, we had another extern join us, Cassie Williams. If you want to just stand up so everybody can see you. She's sitting in the row with the other externs. And I'd also like to thank Professor Boyer-Vine and Professor Benares for supplying us with these excellent externs. They've been very helpful. Quickly on the budget, things seem to be steady, so we don't really have anything new on that. We do have some hiring updates. We would like to introduce Christy House, who is our new Chief of Administration. Christy, do you want to just stand up for a second so everybody can see you? We are very pleased to have Christy join. She's only been here a couple of weeks. I think she feels like she's been here 10 years. We've given her so much work, and we're off to a great start with that. So welcome, Christy. I'd also like to announce that Steve Cohen has been promoted to Senior Staff Counsel. If you want to give a wave, Steve, congratulations on that. That also creates a attorney vacancy, and luckily we have Christy on board, who's going to help us work on that. We are still hoping to look into securing office space this spring. Another thing that we put on Christy's to-do list. We made some initial outreach on that, and thank you to Kara Jenkins for sharing the name of her leasing agent. Is still are working on the handbook update, so that's to come. If any commissioners have any ideas, feel free to shoot staff an email at the same time. And welcome again aboard, Christy. We're going to be updating our internal policies and procedures, looking at modernizing the website. Sarah has put a lot of time into trying to figure out what our IT support services consist of. And we are looking at perhaps getting more support. So we have sort of our own little help desk, which we don't have right now. So that's one of the things we're working on. And at this point, I would just like to thank our externs and our wonderful commission staff for helping pull this meeting together, as well as the commissioners for your support. And so that's all I have, unless somebody has any questions.
Now we'll move on to commissioner suggestions. Do any of the commissioners have any suggestions regarding proposals for new studies, topics, discussion of commission procedures, or other general matters? This is the time. Hearing no comment, then we will move on to our next subsection, Bagley-Keene Open Meeting Act.
Okay, so in Memorandum 2025-13, we have some information about the Bagley-Keene Open Meeting Act. At our last meeting, some questions came up about what sort of interaction a commissioner can have with a member of the public outside of a public meeting that is specific to commission business. We had written a memo a while back that was provided to the commission, so we just thought it would be good to refresh everybody's memory and refer you to that memorandum. The big question is how, or caution, I suppose, is for commissioners to be aware that if there's a serial meeting in which, say, a member of the public talks to Commissioner A and then talks to Commissioner B and tells Commissioner B what Commissioner A said, and then on to Commissioner C, same thing. Is there a possibility of a serial meeting? So what we're suggesting is, it's totally up to the commissioners, but what we suggest is that if you are contacted by a member of the public about a commission study, just let the executive director, me, and the staff know, and that way we can give other commissioners a heads up and help you avoid that situation. So that is what that part of the memo is about. The other news we have is, I think everybody's aware that the statutory authority that we're currently operating under to be able to have this sort of hybrid meeting where some folks are in person, some are via teleconference, is set to expire at the end of this year. There is a bill, Senate Bill 470, that is authored by Senator Laird, that would, among other things, eliminate the repeal of the section that the commission is currently operating on under. I think that's welcome news to the commissioners, because it does provide a measure of flexibility when commissioners aren't able to be in person. So that's everything on Bagley-Keene, unless there's questions for me.
No, I would like to thank the director for doing this work. It's very important in terms of our transparency that all the public understands how we're going about obtaining comment and making sure that we meet our obligations and our duties as commission members and don't run afoul of that. So I appreciate that I also believe it'll be a helpful tool as we get new commission members in the future for them to be able to understand the role and see a process that is working. So thank you so much. I will ask, is there any public comment?
John McHale.
Mr. McHale, can you hear us?
I think he lowered his hand.
Thank you, Mr. McHale. There will be numerous opportunities for public comments to try to contribute in the future of this meeting. Now moving on to 2024-2025 annual report.
Yes, this report will be presented by Steve Cohen. So Steve, I'm going to hand it over to you.
Good morning, everyone. Testing, sounds fine. Everybody.
Hey, all of a sudden, everybody's audio is a lot higher.
Hi.
Are
Not
we
in a
now
bad
yelling
way.
at you?
No, it's not in a bad way. I could just hear you a lot better. I don't know what changed.
Great.
Okay.
Thank you.
All right, thank you. So this memorandum presents the Commission's annual report. This would be for 2024 and 2025. Most of the text in the annual report repeats each year, except when necessary to update for activity in the specific year. There are 3 items of business before I ask the Commission to approve the report. First is text which is shaded in gray on pages 3 and 10 through 12, which discusses the plans for work in 2025. That and make sure that there's nothing that the staff has indicated there about the proposed legislative program as well as activities. What? The proposed activities for 2025. We'll change that if anything there is appropriate by the Commission. There. Yeah, next item of business is a report on any commissioner activity over the course of the last year that is related to commission work. You can look on page 25 of the report and see an example of the kind of thing that we report here each year. If anyone has anything to report, you can let me know through email later, but wanted to just make sure everybody is aware that that's something we need to report. The last item of business is to make sure everyone is okay with their summary biographies, which are an appendix, which is also presented with the annual report. I think we cleared them all with you a while ago, but just wanted to make sure there were no changes. And if there are, you can also, again, you can send me those changes. Other than that, we do need to have an approval from the Commission of the annual report and the appendix.
Move to approve.
Is there a second? Is there public comment? Any comments from commissioners? Seeing none, if we can move to roll.
Steve?
Oh, you want me to, I'm sorry. We'll go through. So it's hard to see everyone's Commissioner B.
Aye.
Commissioner Carrillo,
Aye.
Commissioner Carrion.
Aye.
I'm not going to get everybody in order here. Commissioner Jenkins.
Hi, Steve, just to note that on page 24, there's a reference to the ULC, which says UCL. So just
Oh, sorry. Hold on.
so that was noted.
Always great to have eagle eyes on the commission.
24.
The last paragraph.
Thank you. And I'm sorry, I didn't hear what you said though about that paragraph.
The ULC is, it says UCL instead of ULC.
Oh, thank you. Okay, thank you very much. Uh, Commissioner Kubas,
Aye.
sorry, Commissioner Hebner,
Aye.
Commissioner Hebner,
Aye.
okay, Commissioner King. All right, did I call Commissioner Simpson?
Not yet. Aye.
All right, thank you. I think that's everyone that's present.
Motion passes. Now moving on to our next item, status report.
Yes. So this is memorandum 2025-15. It discusses the commission's 2025 legislative program. We presented on this at the last meeting. On the commission's agenda today, there are two tentative recommendations relating to the Equal Rights Amendment Study and the state and local agency access to customer information from communication service providers. We anticipate that hopefully the commission process will be done by the end of this year, and that staff would be seeking our reporting on recommendations for legislation in 2026. We do, since the last time we met, the bill introduction deadline has passed, and we do have AB 1073, which would task the commission with a new study. If this particular study seems familiar, it's because there was a legislation last year that would have tasked the commission with a nearly identical study. In a nutshell, the study would require the commission to study the recusal of judicial officers for prejudice and conflicts of interest. It would also expand existing judicial officer removal rules to appellate justices whose decisions are reversed by the California Supreme Court. So, and more specifically, the bill would require the commission to study the recusal process. Last year, when the bill was introduced, we did reach out to the Commission on Judicial Performance to talk about the bill, because one of the requirements is that the commission would consult with the Commission on Judicial Performance. I intend to do that again this year as we monitor the bill's progress. One thing to note is that because it's a little bit different or additive to what the commission usually does in terms of gathering data, the staff does believe that we would need to hire a consultant. So that's something that we'll make the legislature aware of as we continue to monitor the bill. So that's the summary on the legislative program. Are there any questions?
Is there public comment?
No vote is needed on this one.
Our next item, 4, is a special order item. It is for the recodification of toxic substances statute, which is study E200. We have an ASL translator who will be providing services, translation services for this topic, and we will not commence until 10:30. According to my clock, it's 10:27. So why don't we take a little quick 3-minute break? Folks can get some water if they need to and come right back. Thank you. Good morning again. We are now reconvening at our 10:30 mark, where we will be looking at our agenda item 4, which is our special order item for the recodification of toxic substance statutes. We are very lucky, privileged to have a wonderful ASL translator thank you so much for being here. We appreciate your services and your ability to ensure that our folks be able to understand and be part of this process. So please let us know if you can give us me a sign that you need us to slow down. I personally sometimes need to slow down. So please let us know so we can work best with you. Thank you. Now moving to the cumulative draft of material previously approved, which is memorandum 2025-16.
Like to present?
That's fine. Thank you. So as has been the case in recent meetings, we have two memoranda in this particular study to look at. And again, the first is this cumulative draft of provisions that the commission has previously provisionally approved for inclusion in an ultimate tentative recommendation that would recodify Chapter 6.5 of Division 20 of the Health and Safety Code. Meeting, we have been presenting a set of new provisions. The commission provisionally approves recodification of those provisions to be placed into this cumulative draft. And then we present the cumulative draft at the next meeting as basically a reference typically, so you can see the progress and members of the public can see the progress. This particular memorandum presenting the cumulative draft is more than a reference document because the staff has proposed a reorganization, not a substantive reorganization, but a reorganization of where the sections will be Health and Safety Code after being recodified. The rationale for the proposed reorganization is that Department of Toxic Substances Control, which deals with these provisions on an everyday basis, believes that there would be confusion and possible error based on the fact that the regulations that implement some of these code sections have the same numbers. They're overlapping numbers to the numbers that were picked quite some time ago for the new code section numbers in the Health and Safety Code. It wasn't a big problem to change the numbers. We just basically moved them all to another location where there's plenty of room and there would be no overlap. And certainly this was the request of DTSC as well. The only theoretical issue is, I mean, it doesn't seem to be a substantive problem in any way, but we have recodified, or we are in the process of recodifying the second of two chapters that relate to toxic substances. The one which the commission did quite some time ago was chapter 6.8. And the subject matter of that chapter is about cleanup of toxic substances, whereas chapter 6.5, which is much longer and much more extensive, deals with toxic substances generally. So logically, there was a thinking that that should come before 6.5 should come before 6.8 rather than after, which is the area where we're suggesting that it go. And we're suggesting it go where we want to put it because it's the only place we can fit it without running into overlap with other code sections or potential overlap. It's a little difficult as we're doing this to know exactly how many code section numbers we're going to need because many of the existing sections are extremely long. And so the commission has broken those sections up into multiple sections and tried to leave space between them. So this is our best guess as to where this would fit, and it will clearly fit where it is now. We just felt it wouldn't fit where it was before if we tried to move it and keep it before the recodification of chapter 6.8. So questions about the proposed reorganization? Okay.
A quick question. So
Sure.
the proposed reorganization in front of us is consistent with what DTSC has recommended for how to put it together?
Yes, that's correct.
Okay.
I mean, I will say that they requested that we definitely change the section numbering that we had before and that we move it, and they offered us one of two choices where they said they would be happy, and this was one of the two
Okay,
choices.
got it.
And
Thank you.
First one they offered probably would not work.
Any additional commissioner questions? Being none, do we have public comment on this item? Is there a motion for the commission to provisionally approve the reorganization of the cumulative draft presented by the memorandum?
So moved.
Is there a second?
Right. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King, Commissioner Simpson.
Aye.
Thank you very much.
Motion passes. Now we'll move on to chapter 6.5, recodification of the next portion, which is memorandum 2025-17.
Yes, thank you. So this is, once again, as in previous meetings, this is a proposed recodification of another chunk of existing code sections in chapter 6.5 that would go into the recodification that the commission is proposing. Attached the draft. We've again explained the general drafting approach. If the commission has questions, I'm happy to field any questions. Otherwise, again, I would seek a provisional approval of these recodified provisions to be placed into a tentative recommendation, which will be coming at some point down the road and would also appear in the cumulative draft that you will see at the next meeting.
Have these changes been reviewed by DTSC as well? Or not yet?
Well,
That's next
I
process.
would say, I would say not yet. It's the timing is a little bit of an issue because they don't have a lot of time between when we release the memo and when the meeting is. And in the past, they have not been commenting, although occasionally they might say something. In general, they are looking at the provisions when they're in the cumulative draft. To some extent, they kind of need to see the whole picture to get a better sense as to whether there's a problem or not. So they might be fine with the wording of a provision as presented, but then juxtaposed against another provision in the cumulative draft, they might see some problem. That's why we have these various steps here.
Got it.
But
Okay, so that'd be the next stage after this.
yes, I would say yes.
In that case, I'll move approval.
Just to be clear, the motion would be for the commission to provisionally approve the proposed recodification in the attached draft for inclusion in a future tentative recommendation.
Correct.
Maybe we should check for public comment before the motion.
Yes. Is there public comment?
Commissioner B,
Aye.
Commissioner Carrillo, sorry,
Aye.
Commissioner Carrion,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins.
Aye.
I didn't hear, sorry. Okay, I think the sound, I didn't hear it, but okay. Commissioner King. Commissioner Simpson,
Aye.
thank you very much.
The motion passes. Now let's move on to section state and local agency access to customer information from communication service providers, study G300. That is the draft tentative recommendation is memorandum 2025-18.
Sarah, would you like to present?
Thank you. Good morning, Commissioners. I'm presenting Memorandum 2025-18 related to the notice of subpoena. This memo presents the draft tentative recommendation submitted for approval to release for public comment. In addition to several technical amendments, I added a comment to the proposed language and proposed a deadline of May 16th, 2025 for public comment, which means the commission could consider any public comments received at its June 26th, 2025 meeting. Does the commission have any questions or comments?
I have a comment. In the recommendation section, in which you've identified the 3 following steps which are required, I would ask in subsection 1 that we also include the statement regarding the need to request an order from the court if the government entity is unable to locate the subscriber. The order of the court, as you've mentioned in the memorandum and as is already in the text of the proposed law, would be that the court would order the subscriber to receive the subpoena from the actual communication services provider and not the government entity. The language is already in the text of the statute as proposed, as well as earlier in the memorandum. So it would be more of just to make sure that we're consistent.
Will do. Thank you, Commissioner.
Are there any additional comments? Is there public comment on this topic?
I don't see any. No.
Is there a motion to approve?
Approve with changes?
Yes, with the changes.
Oh,
Thank you
great.
so much.
You're welcome.
Thank you, Commissioner B.
Second.
Commissioner Carrion,
Aye.
Commissioner Simpson,
Aye.
Carrillo,
Aye.
B,
Aye.
Kubas,
Aye.
Ebner,
Aye.
Jenkins,
Aye.
King. Thank you.
Thank you. The motion passes. Does anyone need a morning break? Just in the audience? All right, let's keep going. Thank you. Now moving on to agenda number 6, item 6, Equal Rights Amendment, Study 1-100. We have on our agenda the draft tentative recommendation in memorandum 2025-19.
Thank you. Similarly to the previous item, this draft tentative recommendation is submitted for approval to release for public comment as well. In addition to several technical amendments, the tentative recommendation was updated to reference several recent federal executive orders that touch upon some of the issues addressed in the background portions of this study. However, these executive orders do not impact the analysis of state law or the staff recommendation. As with the previous item, I proposed a deadline of May 16th, 2025 for public comment, which means the commission could consider any public comments received at its June 26th, 2025 meeting. Does the commission have any questions or comments?
A couple questions. Can you hear me okay? So I know things are in flux with the federal administration, and I appreciated you including the executive. If there's any risk to passing this legislation? And that's probably an impossible question to answer, but I just wanted to flag that that occurred to me as a possibility.
I don't believe that's something I could speak to. It's more of a political question than a technical question. The proposed recommendation does not substantively change any of the laws. We viewed it as more of a restatement of existing law, but in as much as it does towards issues that are unfortunately controversial at the moment, I think that would be something that the legislature may consider when deciding to take this up next session or not.
And then I just wanted to say I was heartened as I read the memo so that the laws align with the ER.
Thank you.
Commissioner B, your audio is cutting out.
I'm sorry, what was that, Commissioner Carrillo?
Commissioner B's audio is cutting out on the Zoom.
I may not have been close enough. I was basically thanking Sarah for her work on this project.
Appreciate it. And Sharon helped as well with the executive orders. So.
I also would like to make a comment. Particular, I believe that given the state of the law in which these executive orders do not impact California law, I don't believe we need to go into the detail about these executive orders. I am more interested in the analysis in the body of the text of what is the law that says that we are not required, how it doesn't impact California law, and rather to mention these executive orders in the footnotes rather than to discuss them in so much depth. I think it will be very helpful for everyone in the public to understand why is it and where the law comes from saying that these executive orders do not impact California law, and to make it very clear that California law, as discussed in the memo, which doesn't obviously need further adjustment, it provides very robust protections regarding gender orientation, gender sexuality, and gender identity. So I think that that would be the direction I would request staff to move forward. Is there any additional comments from commissioners?
I had one more question. I noticed in the CDCR section that they use the word cross-gender, and I hadn't seen that anywhere else in the memo or I'm aware of, and I just wanted to double check that that's the appropriate language to use.
Part of the broader recommendation was that CDCR, we didn't think was really following, I think particularly their own standards in their guidelines. So I'll review that section again and make sure that it's in alignment. So.
Maybe just, so I haven't followed it too much. What is the status of the ERA currently? I mean, that's what sort of triggers this study at, if the ERA deemed to be part of the Constitution, what is the status of it?
Kind of in a holding pattern at the moment. Technically, a sufficient number of states have ratified it, but there was a deadline placed on it that preceded the final states being able to meet that. And there is some issue as to whether it could be brought forward by, I believe, the clerk to ratify it. So at the moment, it looked more likely that it was going to pass when the study was initiated than it does now.
But what would it take? Like a Supreme Court decision or something for it to make to
Oh.
decide whether it's there or not?
Unclear. I think there needs to be a determination as to first whether that deadline was appropriate or not. And several of the states who previously ratified it rescinded it, and I don't think that that has precedent. So there's a number of legal questions that would need to be resolved before the next administrative step, which would cause it to be adopted.
I don't recall, as proposed in the tentative draft, would these statutory changes be contingent upon? No.
Not at all. In fact, currently California's laws are actually arguably in some instances more robust
Right.
than even if the ERA was going to pass.
Right.
So this just consolidates and clarifies our own law regardless of the ERA's status. So.
Thank you.
Any other comments or questions from commissioners? Do we have public comment on this item?
Not at this time.
Is there a motion for the commission to approve the tentative recommendation with the additional changes that I mentioned?
So moved.
I'm sorry, I didn't hear that. Was that Commissioner Hebner?
Yes, so
Thank you
moved.
so much. Is there a second?
Second.
All in favor? Let's go ahead and do a roll call. Will you be doing that, or Sarah?
Sarah?
Sure, yes. Commissioner Carrion,
Aye.
Commissioner Simpson,
Oh, aye.
Commissioner Carrillo,
Aye.
Commissioner B,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
and Commissioner King. Thank you.
Great, the motion passes. Now we'll be moving on to our next agenda item 7, which is the terminology relating to persons with disabilities, study 1 or I dash 200.
And Steve will be presenting on this study. Thank you, Steve.
No problem. So this is a new study for the commission. The commission has been charged with revising terminology in the existing codes that currently refer to dependent adults and dependent persons as defined in sections, to substitute more respectful terminology. The legislature has also directed the commission in doing the study to convene a working group of some specified members and then some more generally described members, so that we have presumably as broad a range as possible as to the best way to accomplish this assigned task. So the staff's first step here in the study is to convene this working group. We have been contacting various people and asking for additional contacts, as the memo indicates, which is just a status report. We have a number of groups that are already committed to being part of the working group. There's actually several more that we have feelers out requesting that they consider being part of this working group. And we are hoping to start meeting as soon as we're able. Questions?
Hearing none, is there public comment on this item? Is there a motion to approve the tentative?
No, there's no
Oh, excuse
motion
me.
needed in this one.
Oh, thank
The
you. That's
report.
correct. On a voting roll. All right, thank you so much for that status report.
All right, thank you.
So we are now up to our 8th item, which is our antitrust law. However, we're going to go ahead and take a break right now.
And we would also like to thank our ASL translator for your service. We very much appreciate it. We're done with the portion of the agenda that needed your translation. Thank you.
Now, one of the things, we can take a break. We can also take our lunch early at this time, since I do believe that the public has, publics and people interested in the antitrust study were informed that this would be an afternoon session. So given that it is close to 11, but not yet, probably take a longer lunch break, if that is agreeable.
I think hour would be.
Is there a preference from commissioners that are present or via teleconference? There's no preference. So why don't we come back then in 1 hour at noon? All right. And if we can please put a note stating that we will convene the afternoon session at noon, not 1:30. Everyone. All right, good afternoon, everyone. We are reconvening here April 3rd, 2025 for our afternoon session of the California Law Revision Commission. We are currently at agenda item number 8, which is our antitrust law item. It is study B as in boy 750. Now we're going to go ahead and move into our next item or subsection of that item, which is the draft language options for single firm conduct. It is memorandum 2025-21.
That is my item, but I will say that Sarah is here in the room. She's a big contributor to this, as well as Cheryl Johnson, who I believe is in attendance via Zoom. There she is. And I ask that the both of you interrupt me at any time. If I'm making a mistake or if I'm missing something, please, we need to hear your voice. And having recognized Cheryl and Sarah's great contributions to this memo, I would also like to recognize our 4 externs from the University of California School of Law at San Francisco, who we have tasked with the number of research projects related to this study. And in fact, we're going to hear briefly from one of our externs in a few moments about her contribution. So this memorandum presents staff recommendations for draft legislation to address single firm conduct in California, as the commission discussed at its January 23rd, 2025 meeting. At that meeting, the commission indicated a preference for language targeting single firm conduct that does not simply mirror the federal Sherman Act Section 2. And as the commission is aware, California currently does not have a Section 2 corollary. And the reason for doing that would be to avoid importing limiting federal jurisprudence on how that the Sherman Act is interpreted. So this memorandum presents 3 options for single firm conduct to be added to the Cartwright Act. The memo indicates advantages and disadvantages of adopting each potential option. And then in addition to the options, we have developed what we're calling at this point finding and declarations language that would make clear what the intent is behind the provisions. One of the things we're going to ask the commission for feedback on is, while the legislative findings and declarations can be in statute, they do not necessarily have the force and effect of law. They're more guidance to judicial officers on how to interpret the law. And so it may be prudent in some or maybe even all instances to make the language mandatory in statute. This isn't the only language that the commission or the staff will be presenting to the commission at the next meeting. Our intention is to follow up on what we hear back from commission feedback on these proposed drafts at this meeting, and also to address mergers and misuse of market power and other issues that the commission has identified as we've gone through this process. At this point, we're not requesting the commission to make a decision or to select any particular option. Rather, we're seeking feedback. The memo, we did post it with this proposed language 10 days prior to the hearing, but that doesn't leave a lot of times for interested parties to actually, look at the language, weigh it, and weigh in on it. So we thought it would be helpful to the commission if we could hopefully encourage more public comment to come on this specific language. So it's something the commission could consider it at its next meeting. I will note that we have 2 supplemental memorandums with public comment, one from the California Chamber of Commerce that I think continues to have the position that California doesn't really need to change its antitrust law. I'm sure we'll hear from the representative later during the public comment period, so I don't want to misspeak. And then in the most recent submission we received from a coalition that the commission has become familiar with, they actually are urging the commission to focus or adopt the option 2 in the memorandum.
We have laid it out.
That is correct, our understanding, and of course, they didn't have, commission drafted language at that point, but our understanding was that that coalition in particular was very interested in the single firm conducts report, which option 3 draws a lot on, but having reviewed this memorandum, that coalition is more focused on the proposed option 2. So I mentioned that we had our wonderful externs helping with this report. I'd like to give Flo a time, Flo, a minute to get to the podium so she can explain the research briefly that she did. She basically went through all state law and to see and made a summary of what other states have relating to something that's similar to Section 2 of the Sherman Act. So Flo, take it away.
Oh, thank you so much. And good afternoon, commissioners. I prepared Exhibit 8 for Memorandum 2521, which is a comprehensive survey of the 50 states' antitrust laws. The chart lists each state's single firm conduct statutes when they were present, as well as the purposes and legislative findings, harmonization provisions, and merger language. Anyone has any questions? Anyone have any questions?
Well, I'd like to commend you in your work. It is an exhaustive summary appendix that I think will be very helpful to antitrust practitioners and those in the field. And hopefully we will continue this because the type of work that the commission is excited and eager to do to assist the folks and legislatures understand what is the current state of the law on this issue. So great job. We're very happy to have you here and great job presenting today.
Thank you.
Okay, so moving on with, and thank you very much, Flo, for your presentation. Moving on to the various options that are presented in the memo. The first one you will see, which is an option 1, and that option uses language that is similar to the Sherman Act. We have it set forth in the memo. As we gone through this process, the commission has heard concerns about uncertainty and if California departs from federal law, would that create uncertainty? All businesses are currently subject to Sherman Act Section 2, and the courts have years of experience interpreting Section 2. A basic provision like this also avoids challenges that could arise when courts are interpreting a completely new law. At the same time, we want to recognize that based on public comments we have received to date, that the commission has received to date, we believe that there are those who will argue that this more modest approach does not go far enough. As I explained earlier, we do have a section in this memorandum that has legislative and findings and declarations, one of which would sort of untether California law from the federal jurisprudence on how Sherman Act Section 2 would be interpreted by California courts. If the Cartwright Act is amended, those findings and declarations would work well to strengthen this base provision. As I mentioned earlier, and as we mentioned in the memo, the issue of whether the commission is interested in findings and declarations versus actually putting requirements in state law so it's clear what is intended for courts to do is something that we would certainly appreciate feedback on. Does anybody have any questions at this time, or should I keep going? Yes.
Maybe just a clarification. When you say that basically importing Section 2 into California law does have lots of court experience in interpreting it. That just federal courts, or is that state courts? I mean,
So I'll let Cheryl weigh in on here, in on this, but my understanding is that primarily it's interpretation by federal courts, and it includes federal courts analyzing California state law and not necessarily paying attention to what the California Supreme Court has said about antitrust laws. And Cheryl, do you have anything to add to that?
Yeah, well,
You're on mute.
courts have exclusive, I'm not on mute.
Having trouble hearing you, Cheryl. Still can't hear you.
It looks like you, there you go. You unmuted.
Okay.
get close to your microphone.
We cannot
We
hear
can
you, Cheryl.
barely hear you.
Can barely hear me. Okay, I have this microphone. I wasn't very well. Can you hear me now?
Can't hear you.
Can you hear me?
So Cheryl,
Can you hear me now?
There you go.
Yes.
Okay, I took
A
away
little
the.
louder.
If
Okay.
you can project for us, Cheryl, because we do hear you
Barely hear you.
barely. So it would be
Closer.
helpful if you project as
Yelled.
much as you can.
Closer to your microphone.
Okay, the Sherman Act claims can only be brought in federal courts. So the federal courts are the only people that have interpreted the Sherman Act. So yes, they're the only people who have interpreted it.
Okay.
But what else was I going to say? I just wanted to also clarify that part of the findings that would be part of a Sherman Act 2 include provisions about the most troublesome federal precedent. There's 3 cases that we always talk about as really limiting effective antitrust enforcement. Are you guys
Cheryl,
able?
I'm sorry to interrupt you. I think we're going to need you to speak louder. It is very faint on our side.
Close to your microphone.
I am
Okay.
really close to my computer and it's on 100%.
Yes.
She's
Okay,
coming
then if
across
you
pretty
can
clear
try
on
to
Zoom.
speak louder, if that's
Okay.
possible.
Can you hear me now?
I can hear you, but it's very faint. So the more you can project, it would be best.
Okay. I just wanted to clarify that among the findings, that we have proposed to be accompany the Section 2 language are provisions that disavow the most troublesome federal precedent. Be mirroring, almost mirroring Section 2 of the Sherman Act. We would at the same time be saying we don't like some of the accompanying federal law, and you don't have to abide by those restrictions in the federal law. I'm taking it you can't hear me.
You know, we were able, it was faint. I'm hoping that the public can hear. If not, hopefully someone in public comment can address it and ask for any clarifications that we can answer. Apologize to the public for the tech issues today. As one of our colleagues mentioned, there is new tech that is being used for the time, and I know that staff and our executive director have been here early, making sure things were working, but in a tech-heavy world, these things happen more so than we would like. So would you like to go ahead and continue?
Yes, and I think when I get to the legislative findings and declaration section, we will be covering some of this stuff that we couldn't quite hear from Cheryl. So I think I did make it through option one. Were there any other questions at this time? Okay. Option two, which we are calling the advanced single firm conduct provision. So this option expands upon the basic single firm conduct provision presented in option one by combining it with a prohibition on restraints of trade, a phrase that is used in both the Cartwright Act and the Sherman Act. The language is set forth in the memorandum, and this approach borrows from other states that have both a single firm conduct provision banning restraints in trade in addition to the core ban on monopoly conduct. The advantage of this includes both diffusing Sherman Act's sections 2 singular focus on monopolistic behavior and decades of narrow interpretations and applications. The addition of a prohibition on unilateral restraint of trade is intended to capture the broad range of anti-competitive conduct that may not fall within the currently restricted scope of law, but is more broadly interpreted in state law for multiple actors. Both the benefits and the potential drawbacks to this option is that it departs from federal law, which would strengthen California law. But at the same time, I think that there will probably be some commenters that are concerned that departing from federal law creates uncertainty. And then referring you all back to the legislative findings and declarations again, without having the findings and declarations or something similar that is mandatory in statutes, there's the risk that federal courts may continue to conflate federal and state antitrust laws. So again, we think it's very important that there's something akin to the language in the findings and declarations as the commission moves forward in its considerations. So are there any questions on this provision? Option.
Again, to make sure I understand, this proposal, to a large degree, say that the existing Cartwright Act provisions apply to a single firm as opposed to just.
Correct. Yeah, and that's what all of these, are moving towards that.
Right, but using more of the Cartwright Act terminology.
Yes.
Which then California courts who would be enforcing this wouldn't have to necessarily rely on federal precedent because you're using terminology and different, I guess, standards.
Right, and there is a body of California law that the courts can look to, and we discussed that a little more in the findings and declarations section. But that compared to the first option, this one would go further in strengthening antitrust law in California. And I don't know if we can hear Cheryl. I don't at this point whether she has anything to add. And I apologize again for all the technical problems. Cheryl, did you have anything to add? Okay. So we're having quite the day of technical difficulties. Moving on to option 3, this is the most robust of the options that we're presenting to the commission today. This one would, it would be a clean break from existing federal single firm conduct law and its decades of restricted federal jurisprudence, because it's really new language. Options 1 and 2 rely heavily on existing underlying antitrust and principles governing the analysis of restraints of trade and monopolistic behavior. However, option 3 uses new terminology and a different analytical framework. As the staff worked with Cheryl to develop this option, we spent a lot of time looking at recommendations by the single firm conduct working group. So we're very, grateful that they were able to give us the information that they did. We came up with some draft language, which is reflected in the memo that I won't repeat, but just to explain it a bit, under the first prong of option 3, harm to competition is defined as that which weakens defendants, rivals, and increases or presents a risk of increasing the defendant's market power. The second prong is intended to exempt conduct that benefits trading partners, such as producing a superior product. We note that this general approach to defining exclusionary conduct was also proposed in the federal legislation known as CALERA that Senator Klobuchar is carrying, and the Consumer Welfare Standard Working Group report also looked at that issue. One of the issues that the Consumer Welfare Standard Working Group noted is that some will criticize the exclusionary conduct standard as ambiguous and unclear as to when conduct simply disadvantages a rival and when its impact is of sufficient magnitude to harm competition. The Consumer Welfare Group did have some recommendations on how that could be addressed. While the staff recognizes that the new framework is attractive as a fresh alternative, at the same time, we believe that this particular proposal would benefit from additional clarifications as to its operation and interpretation. If this is something that the commission would like the staff to continue to work on. For example, the second prong uses the term benefits, but it's unclear whose benefits are being measured and to which trading partners the harm must be negating when balancing the market power. There are another example. The memo more fully fleshes it out, but to be efficient, another example is that option 3 leaves some doubt as to the burdens of proof and to the extent in which there is to be some application of the traditional rule of reason analytical framework. So these are all things that we think the staff would need to continue to look at and develop. Would like to note that we have identified some areas for additional research, but that's not a criticism of the single firm conduct working group's overall report at all. It's been very beneficial to our analysis, and when we received it, it was understood as a work in progress. Again, this would be a novel and new approach, and that's one of the things that the commission would need to consider in analyzing whether they believe that this is something the staff should continue to work on. And as with the other options, we also think it's very important to consider the language that staff has identified in the findings and declaration section of this memo, whether it is made mandatory in statute or simply findings and declarations. So with that, I'll ask again, because this one is the most challenging one for me to explain. I'll ask if Cheryl has anything to add.
Well, I've now put on the headset. Can you hear me now?
Yes.
Yes, we can hear you a little
Better.
better, but still, if you can project, we would appreciate it.
Okay, I'm getting emails that people on the line can hear me. I don't know what the issue is, but I will speak into this headset as best I
Okay.
can.
Thank
For
you.
each of the three options, there are the set of preambles and findings, which attempt to delineate a number of reasons why the California courts, in dealing with language, even if it's drawn from the Sherman Act, should be free to reach their own decision. That cites the fact that California law is very different from federal law. It cites specific ways in which it differs. It admonishes the courts to use their own judgment and not to necessarily follow federal courts. And it also disavows several federal cases that have very much limited the enforcement activity under federal law. It doesn't do it by, overruling the cases. We don't have the power to overrule U.S. Supreme Court case, but what we tell the courts is, in looking at our new law that we're proposing, you're not going to require the plaintiff or the government to show certain things that the federal cases. Host has stopped your video. Okay.
Sorry, Sherry, you were muted. I apologize. You were frozen. I apologize.
Oh, okay. Okay. Where was I?
But we can hear you.
Okay.
Cheryl, those of us not in the room are hearing you very clearly and uninterrupted.
Yeah, okay. Okay, so let me go to the preambles should accomplish our goal of untethering state law from federal law. We know that the commission didn't want to see a replication or us simply mimicking federal law, which of course would draw very little objections to the business community, because they're already subject to these laws. They know the laws. The federal courts know these laws. The state courts can obviously see what the federal courts have interpreted. So that the preambles and the findings are our attempt to take different versions of the law and untether them from federal law, using the best of federal law, but rejecting what we consider to be the worst of federal law. On the second option, I know Commissioner Simpson asked, well, are we just applying the Cartwright Act to single firm conduct? I guess in a way you could say yes, but what we have done is created a more general prohibition on a restraint of unilateral. We have banned one or more persons from doing an unreasonable restraint of trade. Restraint of trade is a pretty broad concept. It is one that comes from Section 1 of the Sherman Act. So the Sherman Act 1 says multiple parties cannot restrain trade. The Cartwright Act also uses the term restraint of trade, and it is used throughout a lot of our jurisprudence. So we have this general, I say rather capacious standard that says you're not going to monopolize, as the Sherman Act tells us not to do, but you're also not going to let unilateral actors restrain trade, unreasonably restrain trade. I know we say restrain trade, but in antitrust talk, that means unreasonable restraint of trade. With respect to the third option, we kind of struggled on this one because we wanted to give you an option that was not tied to federal law. So we looked around, there weren't a lot of options out there. What we chose was one that was started by Working Group 1 and discussed a little bit by Working Group on consumer welfare, and it draws on the work of Calera, but it's not quite a finished product, and we understand that. It has a different focus from the normal antitrust formulation. So it focuses on whether conduct hurts a competitor. Now, some of the public comments have said, we don't like that focus. Antitrust should focus on harm to consumers, however you might define that. And some are afraid that by focusing on harm to competitors, that we will encourage disappointed competitors to bring a whole bunch of suits. But that's a criticism. We don't know what the substance of it is, but it does have a different focus. And because it is novel language, that's both the benefit and a huge detriment. If you don't know what the language means, it may encourage people to have creative explanations. So with novelty comes some downsides. So I think that's what I would add to Sharon's presentation.
Thank you, Cheryl. Commissioners, do we have comments? We can take a break for approximately 15, 20 minutes. I would recommend either we take the break now and then receive comments and then public comment, or we can have commissioners ask questions, make comments, and then take a break before the public provides their comment.
Chair, if I could ask a question of Cheryl based on what she just said so that we don't lose the thread, I'd appreciate that.
Great, let's do that. The floor is yours, Commissioner.
Thank you. Cheryl, on the option 3, clause B2, I'm a little confused about the benefits. Could you explain who the sufficient benefits to whom, and what's the nexus between providing benefits and preventing harm? It would seem those are not related concepts. One might provide sufficient benefits to outweigh the harm, but I don't understand providing benefits to prevent the harm.
Well, I must confess that I don't either. That is obviously a place where I think the formulation needs some refinement. You see, there's not a symmetry between the harm that is weighed in the first prong, harm to rivals. And in antitrust lingo, deciding who a competitor is can often be an arduous task, kind of like defining the relevant market. So, and with integrated firms, you may harm somebody at one level, but they may not be your rival. So that's a problem. Then the second prong, you're looking at benefits to the defendant's trading partners. And trading partners is defined as customers and suppliers. Although I don't think that was intended. I think the working groups all recognize that antitrust should be protecting everybody. It should be protecting the consumers. It should be protecting competition as well as competitors. So that may be just some of the problems that these are kind of preliminary formulations is my kind of take on it.
Great. Well, I understand it's preliminary. I'm raising the question simply to flag the degree of confusion. So at least on my part, so the next iteration would have to really dig into clarifying some of those points.
Commissioner Huebner is frozen.
Can you hear me now?
I can.
You look fine to me.
Yeah, okay.
I'm not sure what's going on, but for staff, if this third option is to be progressed further, I think there needs to be a lot of careful thought about that B2 and what we really mean and how it interacts with the rest of that provision.
Clearly. Now, under analysis, you would weigh the benefits and harm from conduct, and you would weigh to see which one weighs more in essence. But the use of the language that the benefits prevent the harm, I'm not sure how that might be interpreted. Nor
Well,
is it clear who would have the burden of proof there.
It also seems to me, though, based on the information that's provided in this more detailed dialogue on the issues, that maybe we need to consider whether we should continue working on option 3, given the issues that it raises and some of the substantive changes, right? We're basically, as you mentioned, creating a brand new language that was previously not there. While I appreciate the staff's work and the working groups work, I think one of the things that we can do is be exhaustive and also be informed in tailoring down the options that we're looking at. And I hope that in public comment, we will hear whether there are any particular interested parties that want us to further go down the option 3 route. Now, I see that Commissioner Carrillo and also Commissioner Simpson, I think you were first. Go ahead.
I had actually a similar thought. I feel like I have a sense of, in option 1, what that looks like and where one would look to what the precedents are. I think as Cheryl mentioned, would we or would we not want to identify specific court decisions that we don't want to rely on. In option 3, it feels to me like there's a lot of uncertainty as to whether if we did this, it would result in greater enforcement or lesser enforcement or no change. And that, my instinct is that I want to consider just sort of setting that aside for a minute, because there's a lot of work that would have to go into revising that, doing some of the stuff that Cheryl mentioned that aren't clear in the language. My instinct would be options 1 and 2 on the table, and at least for the time being, set that one aside.
Commissioner Carrillo, do you have the floor?
Thank you, Madam Chair. I'm sensing a growing consensus that we at least rule out option 3, and that was one of the points I was going to make. I agree with my colleague, the ambassador, that there are significant definitional problems which enhance the inherent unpredictability and risk of unintended consequences in option 3. So if I would propose that we take that off the table moving forward. If anything, I think that option 2 is our Goldilocks solution. Option 3 does too much. Option 1 does probably not enough. So after we take our break, if we unpack this, I have some other things to say about option 2, but I'm in agreement with our colleagues that it sounds like we could take option 3 off the table.
I would like to know if you saw a reaction from those on camera who are present. Our audio is now working. You do not need to project. You will be able to hear you. So that just happened. I don't know if what magic you've done, Commissioner Carrillo, but thank you. Now, so the floor now goes to Commissioner Cubas.
Yes, so for the 3 options, wondering, this is a question for staff, how long the public has had to review the 3 options and provide comments?
So the memo with the actual language has been up for 10 days. And so, that was one reason we wanted to suggest to the commissioners that rather than picking, a single option today, I totally hear what you're saying about option 3, though. I want to acknowledge that, that public commenters may want to provide more feedback on preference for option 1 versus option 3, comments on actual language, suggestions on language. 10 days isn't a whole lot of time for them to be able to do that. So that's why we weren't prepared to come in and say, here's your options, please decide.
Which is great. And from the comments, the written ones that we've received, has anyone been in favor of option 3 from the public comments we've received so far, at least
So
in writing?
Yeah, in response to the memo that's been up for 10 days, no, I do not, we have not received anything specific to option 3. We do have, going back and looking at public comments, there were not specific to any particular language, but there was some showing a favorability to something along the lines of what the single firm conduct working group had put forth, and option 3 is somewhat modeled on that.
Okay, thank you. Because what I look for is to make sure that have provided the most time to the most people for public comment. This is very critical. It's an important issue across the state and federally. We're going to make history perhaps. So that would be my major comment is the more public comment, the more input we have, the better I'll feel about moving forward.
Commissioner King, the floor is yours.
I'm in firm agreement with, seems like the other commissioners that option 3 should. But I want to put a little bit of twist on it. First of all, all 3 of these options are very progressive because California hasn't been in the single firm conduct game before. So it's interesting to me that, we speak of option 1 as being very conservative, but it is pretty progressive. So I'm positing something else. I wish I could articulate it better. I would like to see option 3 abandoned, but I'd like to see an option 1.5. And I mean that quite seriously. Very serious step we're taking that's going to affect the commerce of the state and have effect in the nation. 2 has problems. Even the memo has suggested that there's uncertainties raised by option 2. 1, we're going around saying is very meek and conservative. That there could be even another middle ground, and just for us to understand the issues, for us to understand the difference between 1 and 2, I'm wondering if staff would entertain the concept of seeing if there's a middle ground between option 1 and 2. Because I'm not comfortable, there's an illusory effect that 2 is great because it's a Goldilocks position, it's in the middle and all that. But I'm a little concerned that arbitrary positioning makes it look better. I would like to, because of the uncertainty raised by the memo and the commentary, and there have been good commentaries despite the fact that it's only been out there for 10 days. There's a good article by Gibson Dunn, there's a good article by Covington Burling about these issues. I'd like to explore, is there something else, 1.5, so to speak?
For folks online, while we can now hear you, it seems we cannot see you. Does anyone that is on the teleconference have a comment other
Yes,
than what has been provided?
Yes.
Madam Chair, this is Commissioner Hebner.
Wonderful, you have the floor.
Great. I'd like to endorse what Commissioner Kubas said. While I think option 3 as framed is problematic, I would rather not remove it from the conversation until there's been more time for public comment. I'm not sure 10 days is quite enough. So while I'm skeptical of it, I would like to hear whether there is additional comment before we decide to remove it from the agenda.
Great. I heard another voice from the teleconference. Is there another commissioner that would like to speak?
I would like to add, in terms of the
Thank you, Cheryl.
time that the public has to respond, we had asked whether we should simply mirror the Sherman Act, and we'd sought public comment on essence, on option one for some time. So we have had a lot of comments on option one. I also want to point out that option three came from the Working Group 1 report, which was issued in September of 2024. So people have had a considerable time to reflect and comment on it. And the fact that we haven't received a lot of comments, I guess, may speak for itself. But they have had those two options really subject to for comment for several months.
Can see you now. I see that there's a hand that was up. Is there any additional comment from anyone in the teleconference from the commissioners?
Are we moving
Just-
on or are we taking a break? Are we closing this out?
If there, it looks like, let's just clarify real quick. We are going to be taking comments from commissioners after everyone has made their comments. Then we will take a break, reconvene. I will ask again whether commissioners in between their break thought of something and they have another comment to make. And then we will move forward for public comment. All right?
Thank you.
Commissioner Cubas, you have the floor.
Thank you. Just wanted to comment on that one about the working group product and how long the public has had. I agree that there's been a lot of working group work and reports and presentations. However, this is the first time that I believe the public has seen it in this format in terms of the three. So that's why, in my preference, again, to allow the most time for the most number of folks to comment. I just want to leave it with that. Thank you.
If I can just follow up, that is correct. And that is why we wanted to point that out to the commission in the memorandum.
Are there additional comments? I believe there is. Commissioner Carrillo, you have the floor.
I was going to suggest that we take a break and then I'd like to make a comment when we come back.
Great, thanks for that. Anyone else? All right, we are going to take a 20-minute break. It is 12:49. Let's come back at 1:10. All right, see you all at 1:10. Thank you so much. Commissioner Carrillo, you have the floor. If you didn't get a chance to hear me, my apologies.
I did not, and thank you, Madam Chair. So two things that I think are primarily for staff. Looking at memo 21, page 12, the text of paragraph sub C in the recommendations, directing you to the last sentence, talking about courts shall make their own determinations. I was going to suggest that staff put a parenthetical there so that it reads, make their own determinations, open paren, based on California law, close paren, of whether challenge conduct, et cetera, to make it clear that courts are not intended to use this to make their own determinations based on federal law, which I think is not the intent here. And the second thing, again, this is for the staff. I was a little disappointed to see that the citation format in the footnotes is federal style. A little while ago, the commission decided it was going to use California style going forward with no space after the reporter and the date in the middle. So I don't know how that got missed in the style manual, but I'd like to see it California style going forward.
Staff was able to hear that?
No.
Okay. Regrettably, Commissioner Carrillo and those on teleconference, it seems that we're having those audio issues again. Can you, Commissioner Carrillo, please restate your direction to staff a little bit louder?
And just to
Sure.
clarify, my understanding is that it is working on the recording, and I think I might have actually heard Commissioner Carrillo that time, so I will shut up.
Ambassador, are you hearing me?
Yes, we can hear you now. Great.
Okay, great.
Yeah,
Do you want me to do, they're short, go ahead.
we can hear you very clear. I can hear you very clearly on this line. So the
Thanks.
recording must be picking you up perfectly.
Yes.
Yeah.
But the staff who is present in the room is not. And since you have given them direction, it'd be wonderful if you could restate that direction so they can audibly understand what you're saying.
Sure. Very quickly, page 12 of memo 21, paragraph sub C, last sentence. I'm looking at the portion, courts shall make their own determinations. I would suggest that courts, or that the staff amend that to read, courts shall make their own determinations, open paren, based on California law, close paren, to make clear the intent that courts aren't going to be making their own determinations based on federal law, which I think is pretty clearly not our intent. And the second thing was the footnotes in the citations and the footnotes are in federal style. The commission decided a while ago that it was going to use California style going forward. So I'd like to see the staff update their style manual and use California style going forward as the commission directed. Thank you, Madam Chair.
Are there any additional comments from any commissioners at teleconference or present here in Sacramento? Yes, Commissioner B, you have the floor.
So this is either for staff or Cheryl, perhaps. I'm looking at the differences between option 1 and option 2. And option 2 adds the language restraint of trade, as you said previously, and that tracks with the Cartwright Act. But I'm wondering how that provides more protection, or what exactly does that do? Adding that specific language.
I'll take that, respond to that. It creates a broad prohibition on unilateral conduct, which unreasonably restrains trade, as opposed to the language that says you shall not monopolize or attempt to monopolize. So there are lots of kinds of conduct that may not be captured by the federal language that is in this formulation as well. So it's meant to capture that broader range of conduct other than the more strictly traditional monopolization type conduct.
I see no hands in the teleconference and I see no gestures or hands here. So let's go ahead and move on to what we've been waiting for. We have public comment. We will first take public comment of the people present, and then we will move on to those that have joined us via teleconference. Thank you. Please, if you can state your name and who you are representing, please.
Yes, good afternoon. My name is Eric Ensign. I'm an antitrust attorney with the law firm of Kroll and Mooring. We represent the California Chamber of Commerce in connection with the commission's study of antitrust law. And I will be brief because I know you've still got a lot to get through today. I want to first thank the commission and the CLRC staff for the work they've done thus far on the antitrust law project. It's important work, and we appreciate the work that has been done. And I appreciate the fact that we're here and given an opportunity to comment on that work. I also want to commend this group of bright law students seated behind me for their involvement in this project. I look forward to seeing them in court someday soon practicing antitrust law.
They may be looking for jobs. Just saying,
Well,
right?
given the work they've done here, they should contact me when they get out of school.
For that.
We've received the staff's March 24 proposed language on the single firm conduct provision. And we still need some time to evaluate it. As we've seen today, there's been a lot of discussion about various issues, and we do want to take some time to get you comments on our analysis of the three options, and we will use, I'm sure, the public comment process. So today, I want to just briefly focus on two more basic concepts. That is, one, do we need to revise California's antitrust laws? And two, if we do, what will it cost? These are two basic questions that we have been raising in each of our submissions and testimony before the commission, and we believe that these two questions remain unanswered. The key shortcoming in the proposed revisions is that there's been no study showing that California's antitrust laws are failing. More specifically, there's been no finding that California consumers or businesses are suffering from less competition, less innovation, or higher priced products. Now, it's fair to say that there have been a lot of voices before the commission who have expressed the view that California law should be revised. Those views are personal views and beliefs in our estimation. They're good intentioned and they're helpful, and we thank the commenters for making those comments, but they're not evidence. They're not a measure of whether competition in California is being hindered by deficiencies in California law. And there are probably just as many voices on the other side of the debate, although not many of them have voiced those opinions here in this forum. That's why we've called for an actual independent analysis of competition in California to determine whether it is actually failing before the commission takes further steps in revising the law. The level of competition in California, it's an empirical issue. It's an issue that can be studied empirically, and it's an issue that can be measured empirically, and we think the commission should do that before taking action. A similar concern is that there's been no analysis measuring what the costs will be if California revises its antitrust laws. And I think every working group and staff report has recognized that antitrust policymaking has trade-offs. Regulation can deter and punish anti-competitive conduct, which benefits the marketplace, certainly. But at the same time, antitrust regulation can chill aggressive competition and innovation, which also harms the marketplace. These potential costs and benefits are capable of measurement and estimation. And again, it's our view that this analysis should be done, this empirical analysis should be done before any proposal is made to the legislature. To be clear, robust antitrust enforcement and sound competition policy are critical to California's economy and our continued economic success. But the proposals are not supported by the type of analysis we believe should be performed before we go and revise our antitrust laws. And we therefore urge the commission to take up this type of independent empirical analysis on these issues before moving forward. With that, I'll answer any questions you may have.
I have a couple questions.
Sure.
Well, first point of order, I would like to, I think, correct, I think a misstatement. We actually have addressed the issue. If you look at our agenda from January of 2025, there was a vote that the commission did consider that was publicly noticed and did have public comment as to whether we should be studying this antitrust matters. So that actually has been resolved. It is not an answer that has not been addressed.
May I briefly?
Of course.
No, I understand that, and I appreciate that. And clearly a lot of work went into not only that meeting, but the materials that led up to that meeting. The point I'm trying to make is that that staff report and the analysis of the commission is not based on an independent study of competition in California or costs that may be imposed by revising California's antitrust laws. That's the study that we believe should be conducted before moving on to proposing changes to the law to the legislature.
Now, I understand your interest in having an independent study. How would an independent study work in this kind of magnitude of a law? Because all of these different industries have, nuanced business practices and how they move forward in their business. How would that be manageable?
Yeah, you're correct. It's a big task. There's no question about that. And I am not an economist, but economists measure competition all the time. They do it in private litigation. They do it on behalf of the government. It can be done. As I said, it's an empirical issue that economists study. And is it easy? No, I'm not going to stand up here and tell you it is easy. It will take time and it would likely be expensive.
And
But
who
when,
would pay for that?
well, I believe it would have to be the state, or unless the economists were willing to do it pro bono. I'm not certain. But when you consider the costs associated with that type of study, it is a drop in the bucket compared to the costs that could be imposed on California businesses and consumers if we get this wrong. If we do something that we shouldn't be doing, or if we draw the line in the wrong area, that will have tremendous costs. And so I think the cost associated with doing a study beforehand is a very, very good investment.
I also would like to point out, as a trial attorney myself, when there are experts or studies done, they are very fact-specific regarding the litigation at issue. What you are proposing is that there be a study on all of the businesses in California that may be impacted by antitrust laws. Is that correct?
Well, again, I'm not an economist. I wouldn't know exactly how to specify this kind of economic study, but there's a lot of much smarter people out there who would have ideas, I imagine. And so I don't know exactly how it be conducted. There certainly have been economic studies of different industries in the United States as well in California. I don't know why that couldn't be done here. And you're right that economic analysis is fact intensive, and I think if you find the right economist, he or she can do the job and get us the answers that we think should be presented before we move forward.
It would be helpful, since this is something that you are proposing, if you can come back to us with any referrals for those economists, find out a little bit more of what you envision, and practically how that would work. That would be very informative and helpful to see if that study would be a viable study, first of all, and then the actual ramifications of who would be paying for that, right? The reality of doing such an endeavor, the timeline that it would also be potentially a massive delay to moving forward our work based on a study that is from an independent person that at this point, I don't see how it would be viable, but I love to be corrected. So looking forward to seeing you back with more information about that.
I appreciate the opportunity. We will certainly take that back and bring you more information. Two other quick thoughts. The Motion Picture Association did conduct a competition study of its industry in connection with these proceedings and presented that to this commission a few months ago. It's a very detailed study of consolidation and competition within the entertainment industry, and I think a good indicator that these types of analyses can be done. The other point I wanted to make is on the costs issue. I know that there were cost studies performed in connection with the New York law proposal a few years ago. There were costs assigned to what passage of that law would be. And I also believe that there are two other cost studies in the record here. I'm forgetting the names of the entities that perform those studies. And again, I'm not an economist, so I can't vouch for them. But I know that there are people out there who have tried to measure and estimate what cost would be associated with changes in the law like this.
Thank you. I believe Commissioner Simpson and then Commissioner Huebner also have comments.
Yeah, thank you. There's, it's been a while since I read it, but my recollection is the working group on concentration and competition in California identified a number of markets where there was a lot of competition, a loss of competition, food and ag, pharma, healthcare, some of those things, which suggests, and I think all kind of came to the conclusion that there are problems that need to be resolved. So that's one. I mean, the other thing is, I know that we've been hearing from chamber representatives that with respect to single firms, federal law is basically, we ought to just rely on federal law. Federal law is fine, and we ought to do that. And my, I guess, response to that would be, well, okay, if federal law, if you're suggesting we ought to just simply rely on federal law for dealing with single firm conduct, does that imply, seems to me that it would imply that we ought to simply repeal the Cartwright Act, because if the federal law is fine for single firm, then we ought to rely on federal law for multi-firm. And I don't think that's a realistic view for California, and that, at least from what I'm not an attorney. I don't even play one on TV. That in California has had at least with respect to multiple firm conduct, have had a more robust, broader, and deeper history of anti-competitive conduct than the feds have. So that gives me pause. with respect.
Understood. Let me first try to address the concentration report issue that you raised. You're correct. The California Concentration Working Group did present a report. It was a analysis of 5 national industries, not California-based industries. And it was not a measure of concentration or competition within those industries. There were discussion of competitive issues that have arisen in ag, for example, and other industries. And there was discussion of the problems associated with some of that. There was a lot of discussion about labor and no-poach agreements, for example, in that report. And so our view is that's not actually a study of concentration in California or a measure of competition in California from an empirical standpoint. It is case studies of certain national industries where there have been competitive problems and where those competitive problems have been addressed through either state or federal law. And again, referring back to the MPAA, the MPA and their study that they presented to us a few months ago, in the concentration report, it found or concluded that the entertainment industry was concentrated. And the economic analysis that the MPA presented a few months later reached the exact opposite conclusion. So again, it's an analysis that can be done and we think should be done. In terms of the Cartwright Act, we are not advocating for repeal of the Cartwright Act in any sense. The law has been in place for quite some time. There's been a number of court opinions, both federal and state, that have interpreted the law and what a unlawful restraint of trade is. And California businesses and consumers and professionals know how to comply with that law because of the precedent that's been in place for quite some time. And so no reason to repeal that. Our point is when you create a new law in California, particularly one that's completely untethered to existing federal law, that is when we get concerns about uncertainty, ambiguity, where the line is between anti-competitive conduct and pro-competitive conduct or competitive conduct.
Well, but if we enact a single firm law that is tethered to existing California multi-firm conduct law, doesn't that uncertainty as that great?
I think it is. I mean, the law there is in California about conduct that is covered by the Cartwright Act relates to multiple actors and what they can and can't do. Price fixing among competitors, for example, it's unlawful under the Cartwright Act. We all know that. Creating a single firm conduct law, whether using the words of the Cartwright Act or not, will create great uncertainty about what a single firm can do that complies with the law and potentially violates the law. And that's, I think, the fundamental point we're making is that especially when you get rid of federal law that's taught so many businesses for so many years, there's a real question about what conduct's lawful and what conduct's not lawful. And that's very different from evaluating what two firms in California can do under the Cartwright Act.
Before we forward with a different commissioner's comment, I would like to note that Commissioner Cubas has joined us back in the meeting. She had a previously scheduled work commitment. Commissioner Cubas is a very, very busy person. And we appreciate all of her time. So thank you for joining us back. Now, the floor is yours, Commissioner Hebner.
Thank you, Madam Chair. I'm very comfortable with numbers. Numbers are a big part of my day job, and I theoretically understand the position that we should be analyzing impact of change. I don't believe, though, that there is a way to do that at this stage of the process. We have the A, which is the existing legal structure. We do not have the B, and there is simply no way, in my view, to compare A and B if we only have the A. And I would suggest that there is a proper point in the process for deciding whether change is good or bad, but that's not at this stage in the process when we don't know what the change would be.
Thank you, Ambassador Hebner. I agree with you. We do not have the B yet. And so it may be difficult to study what the B is, but we certainly have an idea of what the B might be. Apologies. And as I said, I mean, there are economists that I think can do this job. They do it in a number of different settings, and I think they'd be able to do it here. And I do want to take the commission up on its invitation to bring more information to the commission on what could be done to answer the question of, is this good or not? Because I do think that the question of whether we need reform of California's antitrust law has never been fully answered in a way that is convincing to me at least, and to my client.
Commissioner King, you have the floor.
Was that me?
Okay. I appreciate your comments, but just to save time, both the commission's and your time, I don't think it's going to be productive to come to every meeting and to say, we don't believe any change is necessary at all. We've read through about 4 opinions of people who've contributed, and the only 2 that say no change is necessary at all are the MPAA and the Chamber of Commerce. So I'm not saying that to be confrontational, but I'm just reiterating the point that our chairperson said, which was we had a discussion about whether or not to change the antitrust laws months ago. And the legislature has asked us to explore, not that we're the ultimate arbiters of this, they have to vote on it, but to explore the changes. So the entire point of this task is to explore the changes. So I'm just saying it would be helpful for the MPAA and the Chamber of Commerce, who are the only 2 out of perhaps 4 contributors who have said absolutely no change is necessary, to understand the thrust of the momentum here, that you would be more productive and helpful if you came with specific recommendations about options 1 and 2. 3 is very disfavored, it sounds like, but even about 3, and whether or not you have a 0.5 or 1.5 or alternates. But I just want to save you time, that you don't come to the next meeting and saying, in the opinion of the Chamber of Commerce and the MPAA, no change whatsoever is necessary. That horse has left the barn.
I understand the momentum that this is gaining. There's no question about that. And I do wish there were others who would voice their opinions on these issues. I can't control that. And for the time being, we will continue advocating for our views. And I understand I don't want to waste anyone's time in doing that. And we will certainly give you our views on the 3 options when we have additional time to weigh in on that. I also want to say, I don't think we've ever said no changes are necessary at all. In fact, I think we've been in favor, I know the MPAA has been in favor of Senator Umberg's pending legislation regarding merger notification issues. We think that's a very common sense change to California law that we would, I believe, agree with.
Commissioner Carrillo, you have the floor.
Thank you. I'm looking at the conclusion of the letter that I think is from Cal Chamber, where it says, we urge the CLRC to refrain from proposing any revisions to California's antitrust laws. And I think you were just telling me you're not saying that.
Well, I'm not sure I'm not saying that. We've, I believe, been on record and believe at other meetings saying that the merger notification proposals that have been created by the ULC and Senator Umberg, we think makes a lot of sense. So if that last paragraph in the letter you're looking at is inaccurate on that point, I apologize for that.
Okay, so let me move on to my substantive point, which is my day job doesn't involve numbers. It involves substantive doctrinal constitutional law. And from that perspective, I would suggest to you that your basic position is any change in law will result in uncertainty, and uncertainty is bad for business by definition. So that's the basis for, at least in the letter, the recommendation that we do nothing, because doing anything results in uncertainty. I have 2 points for you to consider on that. One is, I'm not sure that, unlike in the numbers context, I'm not sure that there's any way to empirically measure the potential effects of a doctrinal change. Will it have large practical effects? Will it have small practical effects? I'm an academic. I can't think of any way to do that. Maybe there's somebody smarter than me who can figure that out, but I don't think that's possible. So then that leaves you with, okay, you and I are both lawyers. How do courts resolve potentially vague statutory language? They reach for the off-the-shelf statutory interpretation tools. They look at where the words in question have been used in other contexts, how they've been interpreted. And, so I would suggest to you that if, as you suggest, there is some momentum developing around either option 1 or option 2, that might, as my colleague Commissioner King suggested, that might inform your next response to us, to unpack for the commission and explain to us what doctrinal changes like option 2, what effects those could have in the courts. I would suggest to you that the answer there is that the courts are going to reach for the body of law interpreting the terms of the Cartwright Act and just apply them to single firms as opposed to in the existing context. That to me does not seem like a great leap for any competent judge. In fact, it's just a hop, skip, and a jump. How is it used in that context regarding multiple people? Now we take those same concepts and we apply them to a single actor. That doesn't seem all that difficult. And if you think that's going to be difficult and it's going to have negative practical consequences, as Commissioner King suggested, I'd like to see you explain that.
We will certainly attempt to do that in our next submission that will address the 3 options that were put forward before the commission a week or so
Thank you.
ago. We will definitely do that.
It would also be helpful if you can review your past letters, and if there's any corrections, that you would include those corrections in any further submissions.
I don't believe there are, but I will certainly do that.
Do we have any other comments? So
Thank you
for
very
your
much.
comment. We look forward to your continued participation in this process.
Thank you.
Can you let me know how many people do we have? We have 3 people that would like to make comments via teleconference. Can you please call the first one?
First, Lucy Shinkensian.
Yes, thank you. Can you hear me?
And thank you so much for being here and providing your comment.
Thank you. Good afternoon. Lucy Chinkezian, counsel at the Civil Justice Association of California. Thank you for the opportunity to testify today regarding the proposed options for single firm conduct language. CJEC is continuing to evaluate the language options and will provide additional public comment later down the line. But we would like to reiterate that the staff has not demonstrated that current state and federal laws are insufficient for achieving the legislature's goal of curbing anti-competitive conduct. Proposed single firm conduct language options 2 and 3 deviate drastically from existing state and federal standards, expanding antitrust law in a way that threatens the competitive practices of all businesses. These changes are bound to result in increased liability for businesses and will lead to a spike in civil litigation, which burdens our state and our consumers. The changes will also make compliance difficult for those businesses operating in multiple states.
As to option 2, defining restraint of trade as including section 16720 creates unfair restrictions in the context of single firm conduct. For example, section 16720B would restrict a business's ability to limit or reduce the production or increase the price of merchandise or of any commodity, which is an ordinary business practice. Option 3's reliance on harm to competitors incentivizes litigation by rival businesses, increasing costs for businesses and consumers. This option proposes the greatest change to existing law and creates numerous compliance challenges for businesses. We urge the agency to be measured in recommending changes to the law, taking into account the current economic climate, which already threatens the survival of many businesses. Thank you.
Thank you. Commissioners, do we have any comments or questions for our commenter? None, we will move forward with our next commentator.
Lee Hefner.
Hello, good afternoon, commissioners. My name is Lee Hefner. I am senior legal counsel at the American Economic Liberties Project. We have been engaged in this process for well over 2.5 years, and I want to maybe begin my comment by congratulating this commission at its extraordinary work. I was listening to the comments of the representative of the chamber calling for an independent study of antitrust law. And I think that this body is that independent study. You all have done incredible work at understanding, over a century's worth of federal and state antitrust law. This is the independent study that representative was calling for. And I would urge this commission not to concede the point that independent study has been in any way insufficient. It has been exhaustive, and we have very much enjoyed participating in that study. I am among a number of organizations who signed on to a letter supporting option number 2 before you. I would like to also kind of respond briefly to the notion that option 2 somehow diverts drastically from federal and state law, which I think is a comment that the previous commenter made. That could not be less true. In fact, the term restraint of trade is baked into federal law. It is baked into the Cartwright Act that dates back before federal antitrust law. We know how to interpret the restraint of trade. And there has been a 1.5 centuries of jurisprudence understanding what that term means. Nevertheless, we are very eager to continue working with this commission as it seeks to explore what specific types of conduct might constitute that restraint of trade, or a misuse of market power as it may be, or an exclusionary conduct as it may be. To the extent we have also opposed or rejected the framework set in option 3, I don't think it's about that word exclusionary conduct. I think it's about the framework that is set up for how to determine whether a violation has occurred, which I think kind of undermines the point of this process. The findings and declarations, I think, are extraordinary, and I applaud staff for their work in putting those together, enumerating that California antitrust law is broader and deeper than federal law. That is straight from a California Supreme Court decision. I think that we can continue to work with this commission on how to create a new framework that has a basis in California law, but nevertheless does not risk the same perils that the rule of reason framework has caused to federal antitrust law. There is a real problem that you all are solving, and there is a reason why the state legislature caused this study to commence. There is enormous concentration among industries in California, and the report on concentration in California, authored by legal experts across the field, many of whom do not agree on everything, nevertheless sought to explore and identify how that concentration has occurred. So we think that there is merit in this process. We applaud the commission on its work, heartily endorse option number 2, and look forward to ongoing continued work with this body. Thank you.
Thank you. Clarification, I would like to point out, I don't believe the commission has conceded any points, but we are welcoming robust dialogue from all commentators, even if they are in the minority in their position. We want to be able to access all of the resources available to them and have those equally prepared and presented to the commission. Thank you so much. Do we have any comments or questions from commissioners here present or in teleconference for our last commentator? Let's move on. Thank you.
We have 7 more speakers in the queue. Michael Strumwasser.
The name?
Michael Strumwasser.
If what we will do is we will just move on to the next commentator, and when we get some acknowledgement from that speaker, I don't want to mispronounce the last name, we will go ahead and plug you into the queue. All right, so let's move on to the next speaker.
Dan Robbins.
Hi, can you all hear me?
Yes.
Great. So first, apologies, I can't be with you in person. This is the week of the most important antitrust conference in the world. So most lawyers that practice in the space are here in DC, but rest assured I'll return I'll return in June.
Testing 1, 2, 3.
Sorry.
Mr. Strumward, we're going to go ahead and take your comment right after Mr. Robbins finishes his comment. So if you can hold on just a second, and we will call your name when it is your time for your comment. Thank you so much. Mr. Robbins, you have the floor again.
Very good. Thank you, and thanks for the opportunity. So just three quick points. One is on this study issue. You know, I think in March of 23, the commission laid out the rules for all these working groups if they were to do objective work. We in the entertainment industry did not believe the concentration study was objective or scientific. Rather than just complain about it, we spent a lot of time putting together a 50-page study I submitted to you in October. So I hope you all have had the opportunity to look at it. And if you have any questions, I'd be glad to answer those. There is robust competition in the space, and the space is under tremendous stress. Just an article in the LA Times about more job losses in our sector. Also, I wanted to say that I submitted a letter at that time too. I'm disappointed because and I've appeared before you many times. I think I haven't made myself clear enough. It's not the MPA's position that nothing needs to change. That's not true. That's expressed in my letter. As you all know, I'm the sponsor of SB 25, which is intended to change our state's antitrust laws. So I just wanted to correct that because some had suggested that MPA stood for the proposition of no change whatsoever. That's just mistaken. And I'll be testifying next week in the Judiciary Committee, and you're all welcome to come. I'm trying to make change right now. Two more points. I also need more time to think about the recent memo, but two points intended to be constructive. Number one is we're looking at single firm conduct. So let's focus on that. All three of the proposals talk about multi-firm conduct. So whether it's conspiracy to monopolize or adding in joint conduct in 2 and 3, this is apples and oranges. If you don't focus on the title of what you're doing, single firm conduct, you'll create a lot of confusion. There are theories of joint monopolization. Those don't hold much sway. They're not highly thought of. I think you really need to focus on the conduct of single firms, like the title suggests, that do harm in the marketplace. So please be careful and try not to conflate that with the multi-firm conduct, which is it's totally different. And then my final point is, and I've mentioned this before, I think we need to be careful about this desire to throw out 135 years of federal law. A lot of the judges that worked on this are very smart people. There's a lot of good ideas. Simply saying that we're going to put that aside when we go into addressing single firm conduct, which is new for us. We don't have a lot of California case law on this. I'd be very careful with that. It's going to cause a lot of confusion. My suggestion is to look at the specific federal cases that you don't think are correctly decided, and just go with something like option 1 and then call out what it is you want to change. I think it'd be a massive mistake to throw out everything. We just have to do this all from scratch. And we've done this before. We've done this before. When the Supreme Court decided that indirect purchasers could not sue under the antitrust laws, California took the initiative and amended the Cartwright Act to say that that's not true under our state law. Under our state law, an indirect purchaser can sue, and that bill passed. I think if you look at option 1 and think about the specific cases that you want to change, just like we did with the indirect purchaser rule, I think back in 1979, that's a much better way to go. It's much more focused and much fewer unintended consequences. So thank you for your consideration of those points, and I hope everyone did read. I spent many hours on my 10-page letter, my 100-page submission, the 50-page economic study. So I hope everyone reads that. We all spent a lot of time on it, and glad to answer any questions on any of that and provide further input too. I appreciate all the work you're doing as a fellow commissioner in a different commission. I understand having difficult issues thrown at you with tons of paper. I can appreciate that more than any of your other commenters.
Mr. Robbins, let me reassure you that we read everything. We read it and reread it. And we appreciate all of your work and look forward to continuing to have your participation in these proceedings. Any comments or questions for Mr. Robbins? Seeing none, why don't we go back to Michael? I apologize for not saying your name.
Michael Strumwasser.
Thank you so much.
Thank you. Can you hear me, Madam Chair?
Yes, we can. Thank you.
My apologies for the bumbling audiovisual mechanics. And thank you, Madam Chair and Commissioners, for the opportunity to speak to you today. I'm here on behalf of the United Food and Commercial Workers Western States Council. I am a past California Special Assistant Attorney General, and in that capacity, I've litigated some of the cases that the working group's reports address. In those cases, we grappled with the inadequacies of federal antitrust law and the holes in the Cartwright Act. I previously appeared in these proceedings before the commission with the presidents of 2 UFCW locals who called attention to the failure of California law to protect labor from employers' accrual of monopsony power, which has diminished unions' bargaining power and depressed wages and benefits. Your staff has given our concerns their careful attention in their memorandum and proposed meaningful reforms that we urge the commissioner to recommend to the legislature. More broadly, we appreciate the superb work done by the staff. First, in giving you 3 options, we strongly support their recommendation of option 2 and urge the rejection of 1 and 3. And I submit that these 3 options do represent the full range of credible reforms. In principle, you could posit a 4th option, do nothing, maybe call it option 0. But I don't hear any support for that option, which would simply perpetuate what is widely understood to have been a 118-year-old drafting error that has to do with now archaic state laws and the process by which California in 1907 adopted the Cartwright Act. So we urge you to adopt option 2, reject 1 and 3, and to adopt the enhanced purpose statement, the statement rejecting federal principles, and the statement rejecting federal precedents. We also appreciate the terrific job the staff did, first by putting together the working groups and ensuring that they had a broad and diverse panels. Just to take, there should be no mistake that these were broadly selected, fully representative panels. Taking just the single firm conduct report as an example, among the academics and other people that were included, the authors included a senior VP and general counsel at Intel, who served on the board of NASDAQ, another lawyer who represented Amazon, Apple, and Microsoft, another member who was a auto industry consultant and consultant to pharmaceuticals and healthcare and internet companies. This is truly a balanced, prestigious, eminently capable core of experts. And diverse as these were, these expert panels agreed unanimously on key points that have been addressed here today. None endorsed an antitrust law status quo. All agreed that California antitrust law needs to be reformed, and all agreed that it should be unshackled from the failed federal antitrust precedents. Now, if I may, I would like to address the objections of the California Chamber reflected in its March 18th letter and today by its counsel. In particular, I want to address its clarion call to inaction, demanding that nothing be done until yet another study is conducted as to whether California even needs to enact new antitrust legislation. I note that nothing has prevented the Chamber from commissioning such a study by its stable of economists. Had they done so, what they would have demonstrated is that such a study will depend entirely on a whole constellation of speculative assumptions. In reality, the costs and benefits depend entirely on inherently unknowable facts. Will the consolidation of businesses continue, or will the dead weight of ever larger mergers take the wind out of the sails of the acquisition movement? Will federal agencies continue their recent awakening from past enforcement slumber, or will they slide backwards? We should also be clear that built into the Chamber's objection is the proposition of Judge Bork that all that matters is what they like to call consumer welfare, what others might just call economic analysis. Bork said that all else is mush. What all else is public policy. And there's lots of times where you might want to accept a reduction in consumer welfare as they measure it in favor of measures of fairness, of equity, of opportunity. So the proposal that they are making itself is inherently constrained. Now, the opponents of the legislation have to acknowledge that federal judicial rulings are neither static nor policy preference free. Judicial construction of the Sherman and Clayton Acts has swung wildly between pro-consumer and pro-business poles without any change in the statute, just judicial philosophy. California is entitled to have its policies reflected in its antitrust law interpreted by its judges. That requires a California antitrust law. And finally, I dispute the basic premise of the Chamber that, quote, there is no evidence that California's antitrust laws are failing, and, quote, competition is thriving in California, unquote. That is not what our public knows. Our public knows that firms with market power are taking advantage of them. That consumers and workers have fewer and fewer options when deciding from whom to buy and for whom to work. That in language that resonates across the political spectrum, the system is broken. It's time for reform. Your staff has ably illuminated the way forward. We support the recommendations of option 2, and there's a rejection of 1 and 3. Happy to answer any questions. Thank you.
Thank you. Do we have any questions or comments for our last commentator? Seeing none, we'll move on.
Peter Leroux Munoz.
Very good. Good afternoon, commissioners. My name is Peter Leroux Munoz, and I'm speaking on behalf of the Silicon Valley Leadership Group, a business association representing companies and research institutions within the innovation economy. We believe the proposed changes to single firm conduct are unwarranted and antithetical to California's historical focus of consumer protection for antitrust law. The political shift towards a more activist approach to judicial review of antitrust in favor of competition will negatively impact innovation and harm consumers, entrepreneurs, and businesses of all sizes. Existing federal law is proven capable of identifying and mitigating improper business practices, and there is no shortage of matters under litigation, both federally and here in California, that speak to the robust tools that state agencies have for pursuing actions. But expanding the scope of antitrust rules to focus on impact to competitors and trading partners puts the judicial branch at risk of punishing companies for having superior products, better business acumen, or market timing. Many of these successful companies in the technology industry provide low or no-cost digital tools for small businesses and entrepreneurs. Targeting these companies via a standard of impact to competitors undermines the digital tools that small businesses, consumers, and entrepreneurs rely on to conduct business. We join with other speakers who have expressed the idea that if change is deemed necessary, certainly option one would be around basic single firm conduct would certainly be the preferred alternative. We hope you preserve the state's historical legacy in using antitrust to protect consumer welfare. Thank you.
Thank you. Do you have any comments or questions for commissioners for our last commentator? And we will move on.
Benjamin O'Brien.
Hi, good afternoon, commissioners. My name is Ben O'Brien. I'm a policy analyst with California Life Sciences. We're a trade association representing a swath of life science companies, so pharmaceutical companies, academic research institutions, med tech device companies, as well as other medical technologies. I just wanted to say we are still evaluating the different options that were proposed by the commission in the recent memo. So we appreciate the extra time to be able to evaluate those, and we will look forward to providing some specific feedback that keeps in mind some of the things that are unique to our industry around mergers and acquisitions and how this single firm conduct changes would affect us. We generally are in agreement with some of the people who have spoken before in kind of wanting to make sure that the commission is evaluating how these changes will impact the economics of different sectors. But again, look forward to providing more in-depth feedback at the next meeting. Thank you.
Thank you. Are there any questions or comments from commissioners? Seeing none, we'll move on.
Carmen Comsty.
Good afternoon. I'm Carmen Comsty, Assistant Director of Government Relations with the California Nurses Association, which represents over 100,000 registered nurses in California. We appreciate the incredible work that this commission and your staff have done for a number of years on this antitrust study. And we commend your thoughtfulness in putting these recommendations together. And I think it's a real testament to the work of the commission to be able to take the charge of the legislature to take a deep analysis of the state of both federal and state law to make balanced and measured recommendations. As other commenters said before, CNA has signed on in support of option 2, and we fully support this very reasonable measure to enhance the existing single firm conduct standard by tying it to existing definitions that in the Sherman Act and the Cartwright Act on restraints of trade. I think it's important that we are moving forward so that we can address some of the gaps that many of us have described in the past number of years with the lack of recognition in California state law of single firm harms that can result. One of the things that is really important to understand here is that California, we're behind the curve when it comes to addressing antitrust and anti-competitive behavior by individual firms, against workers, against consumers, against working people. California is one of only a handful of states, maybe 4 or 5, that does not have antitrust law related to single firm conduct and single firm monopolization. CNA also wants to underscore that we support the adoption of the enhanced purpose language recommended by the staff, because it's extremely important that we get explicit recognition of corporate concentration's potential to have an anti-competitive impact to workers and labor markets. Importantly, employer monopsony results in the dilution of workers' ability to bargain for better wages and working conditions. This power of employers, monopsony power, allows the employers to suppress wages, reduce benefits, or impose unfavorable working conditions on workers who have limited or no alternative employment options. As CNA has mentioned in previous meetings on this study, there's an alarming trend of large health systems buying up competitors only to reduce or close services that they deem to be less profitable. These are types of harm and conduct by individual health systems, large and growing conglomerates, that potentially could be addressed by adopting a clear single firm conduct standard in California law, because the conduct of these large healthcare systems harm local communities, both job loss and the loss of healthcare services for patients, particularly rural and vulnerable patients throughout the state. And importantly, with respect to patients, anti-competitive behavior from healthcare conglomerates can result in providers avoiding low-income areas and communities of color who may bring in lower returns, or increase prices, or increase out-of-pocket costs for individuals, or increase the premiums that employers or individuals pay to insurance companies. I think it's really important here to underscore that ensuring that we have strong antitrust law in California law is an important and protective step for patients, workers, and our community at large, because as healthcare corporations, as other types of corporations in other sectors gain larger and larger market power, they become less and less accountable to patients and workers and to our communities. And it's important that California finally takes a step that we haven't done in many, many years, where we can have the tools under our law that can be enforced by our courts in the state of California to protect consumers, to protect workers, and to ensure that anti-competitive behavior is checked under our system and structures of law. So again, we just to close out, we fully support option 2, and we look forward to working with you all to really look into, as others had said, to really look into what restraints of trade may be, and this is the first step of the ongoing discussions about what should be recommended to the legislature. And thank you again.
Thank you. Commissioners, are there any comments or questions? Being on, we'll move on.
Jennifer Sue.
Hi, good afternoon, Madam Chair and Commissioners. My name is Jennifer Suh, and I'm speaking on behalf of the Writers Guild of America West. We're a labor union that represents thousands of writers of movies, television, and streaming series in California's vital media and entertainment industry. We commend the staff on their work regarding this ongoing study. Our members experience the harms of unchecked consolidation, deregulation, and antitrust under-enforcement firsthand. We've been advocating for antitrust reform for years, submitting materials for the record, and speaking out on this issue, including before the Commission. We're pleased to address the Commission again today to express our support for elements of staff's recommendations to update the state's antitrust laws as it pertains to single firm conduct. Specifically, we urge the Commission to adopt and recommend to the legislature option 2, which affirms that California's antitrust law is broader than federal law, along with adopting the enhanced purpose statement, statement rejecting federal principles, and the statement rejecting federal precedents as statute. These principles recognize that protecting competition in labor markets is an essential component of antitrust law, and that industries have suffered from a bias against aggressive enforcement and a lack of attention towards vertical harms. Significant strengthening of antitrust law in the state, including the kinds of reforms recommended by staff, is urgently needed to guard against future harmful mergers and anti-competitive behavior in California's already heavily consolidated media and entertainment industry. As we've articulated previously, decades of consolidation have transformed our industry into one dominated by just a handful of companies, including Amazon, Netflix, and Disney, who use their tremendous market power to disadvantage competitors, push down wages and working conditions for workers, and raise prices for consumers. Weak antitrust law and under-enforcement have enabled waves of vertical integration and harmful mergers between behemoth media companies, leaving those few dominant firms with tight control over the content that our industry produces, and Wall Street continues to demand even more consolidation. With its recommendations to the state legislature, the Commission has the opportunity to strengthen competition law in California. We urge the Commission to adopt and recommend option 2 and the enhanced purpose statement, the statement rejecting federal principles, and the statement rejecting federal precedents as statute, as proposed by staff in their recommendations for single firm conduct legislation. If enacted, these amendments would improve California's ability to protect fair competition. We thank you for the opportunity to comment and for your work on this important subject.
Thank you. Commissioners, does anyone have any comments or questions? Oh, then we will move on to our last commentator. After our last commentator, there are still the first supplement to the memorandum of 2025-21 and the second. I will request that our executive director present those together, and then we will open up for public comment again.
Terry Ollie.
Good afternoon. Can you hear me?
Yes, thank you.
Great, excellent. Thank you, Madam Chair and Commissioners. My name is Terry Ollie. I'm the Director of Economic Security, California. And we too were part of the coalition of organizations that submitted a letter recently supporting option 2 of the staff recommendations. I guess the benefit of going last is that I get to incorporate by reference the incredible remarks by my colleagues, Lee Hepner, Carmen Costi, Jennifer Suh, and Michael Stromwasser, who I think really laid out a terrific detailed case across some of the most concentrated market sectors in our economy in California, grocery and pharmacy, healthcare, and our homegrown Hollywood industry, and how the concentration in those markets have harmed not just consumers, but actually also have stifled competition in for workers, stifled competition of new entrants, and have just in general concentrated more and more power in ever fewer hands. So I don't need to go into the details of that, but I really appreciate the level of specificity that my colleagues brought to this conversation. And I think that's a good place to thank the staff and the commissioners for your incredibly comprehensive look and exploration of the issue of corporate concentration in California, and really having taken so seriously the mandate from the legislative resolution a few years ago to explore whether our current antitrust statute 115 years in is living up to its the intention, and whether it is equipped to address novel challenges and the modern economy. And I think some of the fellow public commenters who suggested that there hasn't been sufficient study really just feels, frankly, among lawyers, feels like bucking the hypothetical. I mean, this has been, multiple years. I know I personally have spent many, many hours on these commission calls and even longer reading materials and preparing remarks. And I know you, of course, have done manyfold past that since you've been tasked with actually understanding this long history, both of state and federal law, policy, and jurisprudence. So I really just appreciate the work that's gone into this and would firmly reject any notion that there should be more additional study. I also really appreciate the commissioner who suggested that an invitation to hear more from the public. Yes, we have been looking at a lot of these materials for a really long time, but it's only in recent days and really kind of weeks that there has been sort of the devil in the details, if you will, where we've really seen specifics in terms of proposals. And so I think in the coming weeks there will be additional submissions in terms of maybe teasing out and spelling out some of the definitions that are that are being included in these proposals today. I think there is no question in my mind, and I think yours as well, that the why of what we're doing here today is well established, again, by bipartisan experts across many sort of fields and industries and generations of antitrust beliefs have said that the status quo is not working well for California, and that California it would behoove California to have its own antitrust single firm conduct standard. And then the question becomes how. So, as I said at the top, our coalition of organizations landed on option 2, and I think our letter spells out why. Number one, we believe that it reifies the idea that Cartwright is broader and deeper than the federal Sherman Act, and that it is important to have something that really is grounded in that principle. But also, and then I will say too that option 3, as sort of as much as we appreciate the idea of going broader and bigger and thinking about novel approaches to antitrust, I will say that one of the reasons that we landed on option 2 as the option that we endorsed is that not so much that that we're afraid of a big idea, but actually that some of the actual specifics of the way that was worded has a burden shifting test that we actually thought was would undermine and kind of almost reinforce a rule of reason or even maybe be worse than a rule of reason framework. So we can spell that out in greater detail if you'd like, but that was kind of where we were coming from. I will say, in addition, that we think that option 2 paired with the enhanced statement of purpose and the statements rejecting federal principles and federal precedents, those pieces are so critical to providing guidance in terms of how to think about California single firm conduct. And I think they're really very incredibly well drafted and very, very comprehensive. And I just really want to applaud staff for just for the specifics of those statements. And that's something that we feel is absolutely critical and would be just an absolute kind of gaping hole to not have those statements kind of run alongside a proposal around single firm conduct. I think finally, just as as the staff has said in this most recent memo and during this conversation today, this has been there is a stepwise process here, and while there's no vote being taken today, and that's being that won't happen until June, that there will be opportunities to sort of further develop the concepts that you decide to go forward with, and we look forward to providing more specificity around that as well. The term restraint of trade has a long history, but in terms of like what that actually, what are specific examples of restraint of trade and how do you define that term? I think there's room to continue to explore and define, and we look forward to making contributions to that end. So I think with that, I'll close and thank you just so much for the work that you've put into this entire process. And I really think this has been the most robust and comprehensive approach that one could imagine. And I think we should feel really, I feel really grateful that we are at a point where we're taking all of that good work and putting it into detailed proposals. So thank you so much for your time.
Thank you. Do we have any other public commentators?
No, not at this time.
Any questions or comments for our last commentator? Then let's go and move on to the first and second supplement.
So So I actually rolled those in to my presentation of the memorandum. Those supplements relate to public comment that the commission received. California Chamber of Commerce and we heard from several members of the coalition. That was just part of the public comment. I don't know if the commission has more questions or comments, but there are a couple things. I know we've gotten a lot of feedback.
Yes.
But I just would like to clarify what the direction, thoughts are to staff. I can either ask questions. Okay.
That'll be great to guide us through the
So-
conversation.
So there was, I think, quite a few commissioners comments on option 3, recognizing that it needed more work. And also recognizing, and I think even some of the folks who just presented said, well, we appreciate the option 3, but we really like option 2. So I guess it's sort of a 2-part question. We did identify issues that would need further study. Does the commission want us to continue to delve into those? Or alternatively, would the commission rather see if we're getting support, or I guess staff could kind of monitor it, if there's support out there for an option 3 before we do the additional work that we've identified in the memo?
I would recommend, and give staff, I would recommend and give the guidance to staff that at this time that there be no further work on option 3. However, we keep this on our agenda for the next session, and that way the staff will get more public comment, more opportunities, and that may steer additional work or frame it that we don't need additional work. Does anyone want to add to that or have a different viewpoint? Commissioner Huebner, you have the floor.
I endorse the chair's suggestion. My focus on 3 is simply to make sure we've gotten fulsome comment before we make the decision that it sounds like we ultimately will make.
Commissioner Carrillo, you have the floor.
I agree with the chair and my colleague, the ambassador. I think we leave 3 on the table for now, but I don't think we need any further staff work on it. And the purpose of leaving it on the table is to see if there's a groundswell of public support out there for it that surprises us the next time. And if there is none next time, then I think we take it off the table at that point.
I would concur.
So, and I think we're hearing from folks who talked today that even though we appreciate that they have submitted written comments, they intend to provide more in response, specifically in response to the language in the staff memo. We anticipate, and we're actually going to be reaching out on our listserv to our whole community of public commenters, asking them for feedback on the various options. So I think it was Commissioner King who talked about in maybe option 1.5. I didn't hear a lot of other discussion about that, but I guess from a staff perspective, it seems like we're going to have a lot of comment and feedback to the commission, hopefully, based on what we get from the public. And so maybe we think about that in the context of what kind of feedback we're getting about the language that folks have reacted to so far.
Thoughts, Commissioner King?
I'm comfortable with that, but by my proposing 1.5, I was insisting that there be 1.5 ready for the next meeting. But just to be open to the concept, that's not a binary choice. One, as you're saying, is going to be changed by comments, and 2 is going to be. But so maybe what actual 1.5 was to say 1 and 2 are not necessary.
And if I can comment on that too, I would agree that we need more of information, more details on what would something look like in between one and I would back up Commissioner recommendation, just some thought on the part of staff. We don't have to call it 1.5, but what is there in between 1 and 2? Because I personally don't want to be stuck with only having 2 options to choose from. Now, granted, we want to hear about number 3, but I would concur with Commissioner King's comment about something more.
Thank you for that clarification as we move forward with our work. That's very helpful. And we, as far as the legislative findings and declarations and the issue of staff really focusing on what should be mandatory in statute versus something that's merely declaring intent or, sort of the policy behind the legislation. I think what I heard is that the commission supports that staff dive into that deeper and perhaps come back next time with language that's responsive to the concerns about something being mere intent versus actually mandatory in statute. Is that correct?
That's what I understand as well. Commissioner Simpson.
I just had, a couple of comments on that. Just to clarify for folks who don't live in all that much, anything that is passed by the legislature in a bill, even if it says, the legislature finds and declares, that's part of statute. That it is a statute. The question is, should it be part of the code, or whatever it is? And even if it's in the code, it's not necessarily mandatory. It's part of the underlying. It's part of the law that businesses would look at, courts would look at, whatever. And just a couple of comments on some of the language that identified in here. I think I like the basic purpose statement. Something like saying that the purpose of this chapter or this part even is the promotion and protection of free and fair competition, healthy marketplace, consumers, preserving all that that would be in the code as the context for which a court would look at the specific complied with that general direction. In terms of rejecting federal principles, my instinct, and most of you deal with not a whole lot more than I do. I just punish judges, but that's about it. Is that my instinct was say, rather than saying we reject federal decisions on X, Y, Z, rejecting federal precedent, say something like California courts shall not be bound by federal precedent. That the court will need to make a decision based on the facts in the case in front of them as to whether federal precedent may make sense in this particular context or not, but they shouldn't feel like they have to follow federal precedent when adjudicating. Some of these things, whatever it is, restraints of trade shows up in federal law and state law. So my instinct is we ought to assure courts that by state law, they're not obligated to follow federal precedent. The other thing that where was it? Oh yeah, I kind of liked in the first piece of rejecting federal principles, subdivision B, that says actions that restrain trade or create monopoly, monopsony, and can be harmful, whether by unilateral action or by multiple parties, should be treated similarly. That as appropriate direction. Punish single firm contract conduct more than similar multi-firm conduct, that sort of thing. I don't know. That was just my thoughts on.
Thank you. Commissioner Carrillo, you have the floor.
Thank you, Madam Chair. I was just going to unpack something that my colleague Commissioner Simpson said about the binding effect or not of federal law. And I would suggest that staff implement that with language somewhat along the following lines, that federal law is not binding on California courts, but they may consider it as persuasive authority to the extent that is consistent with California law. I think that
makes
addresses
sense.
Commissioner
Yeah.
Simpson's concern.
And maybe the intent of California law? Since we may have the preamble.
Additional comments from commissioners, questions for our executive director? I'm going to go ahead and open it up since we did have a little bit more of a robust conversation for public comment. Are there any persons present or in teleconference that would like to make a public comment at this time? I see none physically present, and I've just learned that there is none on teleconference, which then moves us to our last item of adjournment. All in favor of an adjournment, please say aye.
Aye.
Great. Thank you all so much. We look forward to all of the comments and all of the written materials. Any information, resources that you can share with us are greatly appreciated, and we will see you at our next meeting. Thank you so much.